By way of introduction on this topic, the traditional system of dispute resolution, what we were able to establish is the fact that conflict is something that is prevalent in a society and usually have its origin in many aspects of our cultural life. As a community or a group of people living together, there are many reasons that can lead to conflict. And that's why we're saying that this is more or less like a usual occurrence within the society. And because of that, there is need to discuss how it is caused. And mind you, in the traditional African society, the stage we are looking at is not the stage that we have now, where we have a lot of sophisticated system of dispute resolution. But we are talking about the indigenous African society, which were the time characterized by the pre-colonial era. And the question is, if they had misunderstanding, how do they address it? How are these misunderstandings treated? And we did say that there is practically no aspect of our life that cannot break conflict. So, therefore, they come up at every point in time. And also, it has been said that the gods of the land have role to play in the emergence of conflict within the society. As a matter of fact, it is believed in some quarters that conflict between man and man is usually caused by the gods. That is, when human beings have failed to obey what the God said about a particular matter, then it can cause them to have that misunderstanding. So, we talked about sources of conflict in the indigenous African society. And we know that conflict usually comes from the economic point of view. Okay? And this economic point of view has become, an inevitable source of conflict in Nigeria. As a matter of fact, when you take your mind back to when we were colonized, the colonial masters, of course, made effort to take practically everything that belongs to us. And some people were brave enough challenge this position that, oh, you are taking our resources to other places. And what are you giving back to us in return? Even though in those days, some of our forefathers collected mirror to transfer maybe 100 acres of land, or as the case may be, but it happened anyway. So apart from economic matters, another aspect of conflict is the one pertaining to chieftaincy title issues. And even up to this contemporary time that we're in, this one is still also a source of conflict within the society. And another source of conflict is the breakdown of diplomatic relations among various society. And you hear the likes of boundary disputes. For those of you who were, grown enough when the Ife Modakeke case was fresh, all of these were due to issues relating to the breakdown of diplomatic relations. So these are the various sources of conflict within the indigenous African society that is our focus. But of course, as of today, there are other sources that can bring conflict. So that's for the sources. And for the features of indigenous conflict resolution, one thing that is constant is that this idea of conflict resolution is central to the indigenous African society, because at every point in time, the harmony of the society, peace, and communal living is what is of utmost importance to the community. Hello, class. I believe you can hear me.
Yes, I will hear you,
Yes,
sir.
sir. I am.
All right, thank you. So that is the major features of the dispute resolution system in the indigenous African society. Then the other things we look at are the characteristics of indigenous conflict resolution. And in that lecture, we did explain that oftentimes when there is need to resolve a dispute, that issue or the dispute, they are usually dramatized. And when they are dramatized using dramatic personnel, which include elders, priests, age grade, the chiefs, the king, and all of that, the source of the dispute is seen, the role played by the different parties are seen, and the stage is now set to be able to resolve whatever the issues may be. So, when a dispute is to be resolved, in those days, they are usually done in many places. And of course, that also talks about that unique characteristics of where these matters are resolved. For example, we have the home front, which usually serve as family courts for matters that pertain to the home. So apart from the home, we have the markets. Okay, people can resolve issues in the markets, and then we'll be talking about commercial court, because what they deal with in the court, in the market, are usually commercial matters. So we have the streets, which is like an open court. We also have the palaces. The palaces also serve as royal courts. And I believe this is one that many people were familiar with. They say when there is conflict, they go to the palace to go and resolve it. But we are saying that some of the things that characterize the court system as at that time are the fact that they have home courts, which is also known as family courts. They have markets courts, which is also known as commercial court. They have street court, which is also known as open court. Then the palaces, which is referred to as the royal court. So, unlike those days, today now, while we still have all of these things, you ready? We now have other ones added, like the social media. Oftentimes, when people are quarreling, all they do is that they drag themselves to social media. And then, as on social media, they will probably get their followers to begin to make comments, and thereafter, some other influential individual may intervene and see how those disputes are resolved. And sometimes, even when individuals are arrested for some notable crime, there's usually what we call social media trial, where the name, the picture, the video of the individual will have gone viral. You can imagine when a particular man known as who was a notorious kidnapper, when he was arrested, it was a whole lot of media show. And of course, that is what is particular about the times that we are in. But that is not a formal court, but at the same time, the social media serves as a court for some people. And like I usually say, that most people also are deterred or they run away from crime because they do not want their images to be published online. So, therefore, that is for this time that we are in. But our focus is the indigenous African setting, where we have said we have the home court, we have the market, we have the street, we have the palaces, and so on and so forth. So in today's time, we have the the media houses, which are can refer to as the public court, and also the colonial court of heritage that we have here in Nigeria. So that is for the the characteristics of this system. The another thing that we also need to point our attention to is the traditional institutions for conflict resolution. Traditional institutions for conflict resolution. Now, many traditional institutions for conflict resolution existed in African society, and they were instrumental to the facilitation of peace and enablement of harmony within the society. So what we are saying is that there were institutions that facilitated peaceful coexistence or resolution of disputes in the indigenous African society. And then the question is, what are institutions? Institutions are set up or established organization for achieving some goals of development. For example, the Court of Law in Nigeria is an institution. What is the court set up for? The court is set up for management of disputes and other related matters. So these institutions that we talked about under the indigenous African society were characteristically modeled along the line of public will and associational trust, because number one, the purpose is to see that peace reign in the society, that everything is done harmoniously as one family. Unlike now that things are so bad. In the days of this indigenous African society we're talking about, practically everybody sees themselves as one family. As human race, we are supposed to see ourselves as one. But it was much more paramount in the indigenous African society than what we have at this time. Okay? So therefore, we see that these institutions are set up to play some critical role in conflict resolution. And these institutions include, but not limited to, economic institutions. Like I stated earlier, the market is one. We also have religious institutions, that is, the deities, the ancestors, and the role they played. We also have the social institutions, which comprises of the age grade, the professional association, because in the indigenous African society, for example, the age grade serve as the police of the people. So when we're talking about social institutions that help in management of conflict resolution, we can't but talk about the social institutions. So all of these institutions, which included economic institution, social institution, religious institution, play a vital role in attending to the various conflicts within the pre-colonial African society. So, having established all these institutions, we therefore want to look at the methods of conflict resolution, the African traditional method of dispute resolution. So, we are going to look at negotiation method. We are going to look at mediation method. We are going to look at arbitration method and adjudication method. And last but not the least, we will look at the reconciliation method. So these 5 methods have been deployed in time past to address or as methods of dispute resolution in the indigenous African society. But what is worthy of note is that to date, this system of dispute resolution are still very much relevant in our society, to the point that they are being modernized to suit the modern time. But it doesn't take away the fact that these were methods deployed for usage of dispute management, which has also been beneficial to the indigenous African society. So let's quickly take them one by one. The method. Number one is negotiation method. This negotiation method entails systemic analysis of cooperation, compromise, and consensus to the extent that agreement was reached. So therefore, what we are saying is that negotiation method provides room for cooperation, where parties will say, we have to come together to settle this issue. When they come together, they also make some compromises. They shift ground in order for peace to reign. At the end of the day, they also arrive at a conclusion, which is what puts the conflict to an end. So, under the negotiation method, which we call what we call significance of negotiation method, we say that the negotiation method brings about equal treatment of parties to the conflict. It brings about equal treatment. Nobody is exalted more than the other. Rather, they are both seen as important fellow, because that's also one of the things that can aid amicable settlement of whatever disputes they have. Also, there is usually mutual understanding for the parties to the conflict and the negotiation or negotiating team, meaning that both of the parties understand why they have approached the negotiation process as a way of their dispute resolution. And they believe that once you are able to, understand the dictate or this issue, then it makes the actual reconciliation or resolution of the issue much easier. And then we also note that under the understanding the crucial issue associated with the conflict is also another thing that is paramount in the negotiation method. So, therefore, negotiation method of conflict resolution was a systemic way of reaching point of agreement, thereby involving the tripod quality of cooperation, compromise, and consensus, which are taking time to explain earlier. That when there is cooperation, of course, the people who have agreed to come together. When there is compromise, they shift some ground in order to accommodate others. And finally, they have consensus, that is, they agree on some certain way to put the matter to close. Now, let's look at method number 2. Method number 2 is mediation method. Mediation method. The question then is, what is mediation? Mediation is an act of intervening in a conflict situation. Okay? When you intervene with the intention of restoring friendly relations. Okay? So, meaning that the purpose is to settle the misunderstanding or the issues between the parties. Then, mediation method prevail in the African conflict resolution model to the effect that the parties to the conflict necessarily submit themselves to a neutral party who now judge them. Okay? And that is what we are seeing here, that they release themselves in order for them to discuss and to solve a problem. And like we've said and will continue to say, that the ultimate goal of dispute resolution in the indigenous African society is to see how peace is restored between warring individuals, that is, individuals that have issues with one another. So, it is expected that the society helps people who are fighting, people who have misunderstanding, to settle their differences. And that's why, because the society is geared towards ensuring that there is peace at all times. And when there is breakdown of peace, of course, it brings about anarchy. It brings about underdevelopment. it brings about war and so on and so forth. That's why the gods place much serious attention to passers-by or people who are aware that there is a fight between two individuals and they walk away. No, the passers-by knew that the gods want them to intervene to settle dispute among them. That those days, people just walk past. They don't show interest and they are not interested. But in our contemporary time, people will not walk away. Rather, they will bring their video to record the incident and then put it on the YouTube. Now, this act was forbidden, or anything similar to it was forbidden to the gods, especially because of the fact that they believe that the individual should help others to resolve whatever issues they have. But these days, people make money from it by using it to boost their profile online and attract many subscribers. So that is for that. For number 3, arbitration method. Arbitration method can be simply defined as the enabling will and power to decide and determine a course of action quite instrumentable to decision making. I'll repeat that again, that arbitration can be simply defined as the enabling will and power to decide and determine a course of action quite instrumentable to decision making. So what it means, therefore, is that arbitration method is one of the methods of dispute resolution where in the indigenous African society, and this comes by way of appointing an arbiter, a neutral judge who understand the language of the people, who understand the culture of the people, to participate even in the entire process, so that justice is seen to be done at all points in time. So, if that is the purpose of mediation, what then is the significance of mediation method in conflict resolution? What is the importance or the significance of arbitration method in conflict resolution? Now, what we will say or would like to say is that arbitration method has produced great level of trust. It has produced confidence and mutual understanding in the traditional African society, because the individuals involved, they said the arbiters or those who serve as the judge there, they've helped parties to resolve their disputes or to address their grievances. Then the society becomes better and better by reason of this particular action. So the importance or the significance of this arbitration method includes but not limited to the following. Number 1, the method engaged the attention of the sage and the supernatural in African setting or environment. What we are saying, or we said earlier, is that the gods of the land are also very much interested in having the issue solved. Number 2, the arbitrator rely heavily on the dictate of the supernatural and tradition. So meaning that the tradition of people is what also helped them in arriving at a judgment that is much more suitable for uh, for the society to grow. Now, before I take the question that is, I think, is pending, I need to just conclude my point on the significance of the arbitration method. Number two, outside the first one which we discussed, which is that it engaged the attention of the sage, as in SAGE, and the supernatural in Africa. The other one is the decisions, the arbitrators rely heavily on the dictates of the supernatural and tradition. Then the doctrine, the decisions agreed upon must be satisfactory to the parties involved, meaning that it must not be one-sided. Okay, and then the arbitral venue was conducive enough to allow for the interplay of the supernatural element credited to influencing positive decisions. So, in summary, for the arbitration method, it's a ground for effective resolution of dispute between parties when the custom and tradition of the people are used in order uh, uh, to to preserve cultural heritage, preserve peace and harmony within the society. So, and I take the question of the person who was raising his hand or have been able to answer by way of repeating the point and all that. Okay, the hand has
Yes,
dropped.
yes, sir, you have.
Okay, thank you very much. So let's move on to the fourth one, which is the adjudication method. The adjudication method. Mind you, we've talked about the arbitration method, the mediation method, and the negotiation method. And now we want to talk about the adjudication method. Here, under the adjudication method, um, the system or the method is designed or is not designed against social relations and control, meaning that it is also an institution that is set up to make the society to continue to progress. Okay, this is a method that is set to make the community to progress. But what is the definition of adjudication? I want to define adjudication now, and I say that adjudication can simply be classified as the process of reaching and concluding decision on issues of conflict. Okay? It can simply be defined as the process of reaching and concluding decision on issues of conflict. But we maintain that it is a systemic approach to pronouncing judgment on conflict situation. Systemic in that the person who is serving as the adjudicator will have looked at both sides of the story in order to be able to profile a good and favorable or a fair judgment. So, the African model of adjudication was not such of pronouncing judgment and declaring guilty party, but it was a kind of judgment where punishment was not the ultimate, even though found desirable. Even when judgment was linked with the punishment, it was not a total assurance of draconian punishment. And what this part is trying to say is that yet the traditional African society is not wired to just be punishing people up and down, but also has its focus in ensuring that the society continue to thrive on the foundation of peace, harmony, and other continuous growth of the society. So that if at all punishment will be given, punishment is now given in order to correct either the individual who has committed an infraction, or to make others to desist from doing such things that can further bring the society into disrepute. So, therefore, under the adjudication method, there is usually the declaration of verdict, okay, which we call pronouncement of judicial decision in adjudicatory method of conflict resolution. But before the adjudicator can pronounce a judgment, those judgments must be based on the following. The judgment must be based on the following. Number one, the character disposition of the adjudicator. That is the adjudicator appears to be a trustworthy person who will not give favorable judgment to the one that deserve to be blamed. So their outcome is usually based on the following: the character disposition of the adjudicator, the application of the custom and norms of the society, because it is believed that it is the law of the society that can guide adequately when there are issues, just like the way we use our laws in Nigeria to guide or to address what we do. Then another point is that the manner of probing the truth of the conflict is the manner. The manner in the sense that, oh, how did they do their findings? How did they do their investigation? Was it done in a way that can make an individual to feel that justice has been done or not? Because recently I had a case where we are trying to, to find out the truth of a matter. But the way the people who are supposed to do the investigation, the way they are going about it, one is forced to say, I don't even believe in this system, because they are probably not doing it with the whole of their being. But for the adjudicator, who must be seen to do what is expected in it all. So, in summary, on this method of dispute resolution, this method, the education method, is tailored towards peacemaking, okay, and that is the foundation of harmonious development. So, peacekeeping was indeed the paramount essence of determining the right and wrong in a conflict. So what this particular method simply does is that it helps to identify the guilty person and give some form of punishment, which is to make the person retrace his or her step to become a better member of the society. Lastly, we look at the reconciliation method. The reconciliation method. Reconciliation of peace and strained harmonious relationship characterize conflict resolution method in traditional African society. We have been saying this and continue to say that the society, the community, the indigenous African society was keen and concerned about peace reigning. So when we talk about reconciliation, just like as it is in a normal world, where you try to pacify people who have been wrong one way or the other, to forget and to forgive and forget. So reconciliation method that as a method of this resolution in Africa is done for the purposes of restoring order and normalcy to a war situation. Okay? And reconciliation project develop process as it is tilted towards the society and continue to seek for the development of the society. For example, when the Ife and Modakeke case was, really so terrible, effort at reconciliating them is geared towards the societal growth. Number one, the citizens of the country of the particular area will not be killed anyhow. Then they will stop wanting destruction of government property. Because if they destroy it, government will still have to allocate money for it to be repaired. So the society then often want a situation whereby there will be no room for anarchy or war in the society. So then, how then do we define reconciliation? Reconciliation is a process of restoring order and normalcy to a war situation, like I said, and the purpose is to be able to settle them and bring peace into the society. So, and the third party that is in the reconciliation process must therefore possess the following. For those who listen carefully when we're talking about the last method that we discussed, which happens to be adjudication, we did say that the character of the person is important. Under here too, what are the important things? The important things include number one, ability to listen, ability for interaction, capacity for interaction, then passion for understanding the terms of the conflict, party passion for understanding the issue of the conflict, then knowledge of custom and norms of the society, knowledge and norms of the society, not common knowledge of common and norms of the society, and lastly, discerning mind for the interpretation of fact. So basically, the reconciliation method seeks to restore peace, but in doing so, we always ensure that it is done in a fair way that blesses or that make everyone to feel very safe and secure. So in conclusion on this method, reconciliation method of conflict resolution, as you have discovered, was arguably anchored on the provision of shooting ban, as in SOOTHING, shooting ban, towards promoting peace and harmony in the society. And that is usually the focus, like I explained, and the society will continue to strive that this is achieved. Okay, so that is the summary of that lecture and topic 2, which is the traditional African society. I don't know if anybody still have one or two questions to ask. We don't mind, we can answer you, and then that will be all for the day. And the good thing is that the recording of this class, because this is more like an abridged version of the full lecture, is also available on my YouTube channel, the Law Class, THELAWCLASS. So once you search for that on the YouTube, you will see it, and you will see this recording there, the IC introduction, then the topic will also be there. You can listen to it more and more to understand, and you are encouraged to subscribe to that channel so that when there are new posts, you can, have opportunity to also join the class at your leisure time. Okay, so that is all for today's class. I do not know if anybody has question. Nobody has indicated, so it's presumed that we have. All right, so we call it a day here, and by the grace of God, when we meet, we shall take on a new topic.
I was waiting for you. I was thinking to be.
Thank you, sir.
Like I would have just waited.